In this video, I am going to be sharing with you a unique strategy to win your domestic violence criminal case if you are also dealing with a divorce or child custody issue with the same person. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you how to represent yourself and win your restraining order hearing. So if in addition to being arrested and having to fight a criminal case, you are also in the position I've seen so many people find themselves in, where you are also trying to fight a restraining order in a family court, then this course is for you. You can get your free first class via the link down below. Okay, so let's jump right in. I want to talk about a unique strategy that can give you a leg up in your domestic violence criminal case if you also have a family law case open with the other party, or even if there is no family law case open at this moment, if you have children in common and could open one for custody. Because I handle domestic violence restraining order hearings, which are a type of family law hearing, and I handle domestic violence criminal cases, I'm in a unique position of kind of seeing how things overlap and seeing how can I use one of those to help me with the other one. So I'm going to be sharing with you one that most criminal defense attorneys do not know about, do not think about right now. In a domestic violence criminal case, people sometimes refer to it as he said, she said. It's all about credibility. And if you can show that the alleged victim changed their story, not on minor things, I'm talking about on big issues, then you have a good chance of getting the case dropped, potentially before court, potentially getting the DA to drop it even once they filed it. And if you go to trial, if it comes to that, convincing the jury that the alleged victim is lying. So if the only evidence is really the alleged victim's testimony, then the jury, if they can't believe the alleged victim, should throw the case out. Now, the problem is that in criminal cases, we don't get that many chances to get a statement from the alleged victim. I mean, there's the police report, but that doesn't count because the police report is not actually a statement from the alleged victim, and you can't use it against them. It's a police officer writing up a book report, I guess. It's a police officer writing a summary of what the alleged victim said. But if the police officers were wearing body-worn video, or if they recorded the interview with the alleged victim, then we can use that. 911 call, if the alleged victim made it and they described what they were saying happened, then we get that too. Okay, so there are two statements there. But we as the defense, we didn't get to control what went into any of that. Right? We didn't get to ask questions. The police are trying to be helpful to their alleged victim there usually, and are not going to ask the hard question. In a criminal case, if it is charged as a felony, we get to ask questions at a preliminary hearing, which is a probable cause hearing where the prosecution has to show that they have enough evidence to proceed. But it's a very low burden. It's probable cause, the same standard that they use to arrest you. So not that much evidence has to be shown. Also, the alleged victim does not need to show up for that. Even if they are the only witness and the only piece of evidence, in California, they can just use a police officer to summarize what is in the police report. It's super backwards. And in that case, we don't get to ask questions of the victim at all. Also, the judges really limit us on what we can ask the alleged victim. They limit the amount of time that we can spend. They limit the subject matter. And it's not really a great opportunity to nail them down most of the time. And then the second time is at trial. But at that point, you're already at trial, which is very risky for the defendant in most cases. So that's the criminal case. That's what I'm talking about fighting here. That's what this strategy is for. But in family law, the parties are allowed to take one another's depositions. Depositions are where the other side's attorney gets to ask the other party as many questions basically as they have. And these depositions sometimes can span multiple days. The subject matter of them that is permissible to ask questions about is greatly expanded. So you see where I'm going with this, right? If you have a family law case, or if you have children in common and you can open a custody case, why not have a criminal defense attorney conduct a deposition and get answers to all those questions that you can then use in your criminal case? You can ask them before the lunch break and after the lunch break the same questions and potentially get a different story each time. The idea here is that we want to basically compare the statements, and we want to be able to ask questions and get the answers to any questions that we have as the defense that have to do with this domestic violence allegation. You can take that transcript of the deposition, and now you can use it in your criminal case. You can use it to talk to the DA and say, hey, look at what the alleged victim told the police officers in the body-worn video compared to what they said in this deposition that I conducted last week. They've changed their story substantially. They can't keep it straight. You guys aren't going to win at trial, and potentially get them to actually dismiss. That is one of the only reasons that the DA will dismiss once they have filed a case. They know that they can't win. And how can you win when you have an alleged victim who has changed their story? What are they going to say on the stand at trial? Are they going to tell the story that they told the cops? Are they going to tell the story that they told in the deposition? If they're telling the truth, why would it change, right? Now, if you tell a criminal defense attorney this, they may balk because this is not really what criminal defense attorneys who purely do criminal defense do. But I think most criminal defense attorneys who really want to win would at least be open to this idea. And I mean, one of the problems here is this is an expensive idea, right? I guarantee you that this is outside the scope of whatever agreement you have with any criminal defense attorney that you hire. Does it cost money? Yes, but I mean, this is your life and freedom on the line here. You know, if you paid for college or trade school, how much did you spend on that, right? And how much do you stand to lose if you end up getting convicted here? Now, criminal cases do not last for that long before the judge will get antsy and say it has to go to trial. So if you are going to go with this strategy and have an attorney do this strategy, you should do it sooner rather than later. They should try to start this whole process as quickly as possible. I hope you found this video helpful. And if you do have a domestic violence restraining order case, remember, get your free first class via the link down below. And if you did find this video helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.